A very good evening to all my dear students. Welcome back to the class. Good evening, Almas, Soumya, Ritika, Priyanka Pandey, Astha, Anushka, Priya Mishra, all of you, welcome to the class. Creditor enforces the securities means he can sell the asset. Okay, Astha, I will just clear your doubt in a while. A very good evening and a very warm welcome to today's class. I hope you have revised what we have done in the previous class. And we have started a new chapter, that is registration of charges, in which we have understood the definition of the term charge. Also, we have done types of charges, that is fixed and floating charges. Yes, Mr. M.A. Nidhi, good evening, all of you. So before we proceed further, we are going to have a quick recap of what we did in the previous class. All right. So you all are ready for the revision, children? Everybody? All right. So first of all, the first question that goes to the class is, how do you define the term charge? What is the meaning of the word charge? Good evening, Naina, Mr. AM, Nidhi, all of you. Let me see the students who have joined on the portal also. Meanwhile, everybody is going to write the definition of the word charge in the chat box. Very good. It is an interest or lien created on the assets for the repayment or as a security for the repayment of loan. So that is what we have discussed in the previous class, the definition of charge, which is given under section 2, clause 16. It is an interest or lien which is created on the property or assets of the company. So can I create a charge on the assets of my subsidiary company? Yes or no? Can I create a charge on the security of subsidiary? You say yes. Even it can be a holding company. Yes or no? So any of its undertakings in which at least 20% of the shareholding is there. So it can be any undertakings that is associate subsidiaries. And this security is being created for the purpose of repayment of the loan. Security includes, charge includes mortgage. What is the difference between the word mortgage and the word pledge? Can anyone tell me what is the meaning of the word mortgage? When we have specifically used the word mortgage, what does it mean? What are we trying to explain with the word mortgage? Mortgage is the word which is used specifically for the immovable properties. Like if a company is taking a loan and it has given its office or land or building as a security. That is the meaning of mortgage, girvi rakhwana, hypothecation of assets. So I told you in the last class how interest is defined. Can anyone tell me? How do you define the interest that is created? Lien, we all know we have the physical possession in hands. Excellent, Soumya, Naina, Almas, Anubhav, Asta, excellent. All of you are giving great answers. So interest is when the transfer property is given in the hands of when the property papers are given to the bank. Suppose we are taking a loan from HDFC Bank and we have given the mortgage. So how will we give the property? We will give the property papers. That means the interest is now created in favor of the property. The charge holder is having the interest, means he's having all the ownership documents. Okay. After that, who is going to define? There are two types of charges. What is the meaning of fixed and floating charge? What do you understand by the term fixed charge? Can I use the fixed charge when it is created where any charge has been created against my fixed asset, can the company use that fixed asset? Okay, everyone says yes, ma'am. Can I even sell my fixed asset against which charge has been created? Excellent. You cannot sell where the, yes, Asta, it can be having a charge on the assets of subsidiary holding and all these companies. Mortgage is for immovable assets, absolutely correct. Pledges for movable goods, all the answers were correct. Yes, you cannot sell the fixed asset unless you have taken the permission of the lender and the new person is ready to repay the payment. Shailaja, Anushka, Rajvi Ray, Mamiti Sethi, Memory, Almas, Naina, Soumya. Excellent answers given by all. Priyanka Pandey. All of you have given the correct answer. Good. So this really makes me proud of all of you. Yes, Rajveer, we are coming on the floating charges also. But let's first find up the fixed charges, because fixed charges, such kind of questions can come in a way of a case study, that where the charge, any assets are under fixed charge, can you sell them? You cannot sell them. You're only permitted to use them. But if you want to sell them, you can sell it with the permission or a consent of the charge holder. Means you will ask the bank that, are you okay if I'm selling these assets? If Reliance is given a charge and Reliance wants to sell the asset to Tata Motors, now Tata Motors will have to repay the loan against this asset. So they will have to take the permission. The bank will check the credibility of the other company, that is Tata Motors, who's buying the assets. So they will find themselves satisfied that yes, we are happy with their credibility. Now we can, we allow you to sell your assets to another new buyer. Fixed charge is vacated when the money borrowed against the asset is repaid. So in today's class, we are going to understand section 82, how this money borrowed is returned and how the assets get free from the charges. After that, we have spoken about the floating charges. All of you have already answered, some of you, that these are the fluctuating charges like raw material, stocking trade. Can we give the debtors also as a security? Can I give the debtors of a company, can be given as a security? Yes or no? Absolutely, yes, you can give your debtors. Means now, whatever payment I had to receive from the third parties, bank has been assigned my debtors. So tomorrow, my debtors, if I don't repay the loan, my debtors will directly make the payment to the bank. This is the meaning of debtors being assigned as a security. Assets can depend upon the charge, both present and future. Means your assets keep fluctuating, you keep borrowing and keep selling them. When does the crystallization of floating charge happens? Anybody who would like to explain, throw light on this point, because this is an important question. If fixed charge asset is sold but loan is not repaid, then Rajveer is asking a very interesting question. So if the fixed asset has been sold but the loan has not been repaid, then you will take the permission from the lender. Bank will ask them that my loan is still pending, I have not repaid it. Once you have repaid the loan, then why will you take the permission? You don't need to ask for anyone permission. Okay, Rajveer, then you can send, then it is free of charge. बट जब तक उसके ऊपर सिक्योरिटी है, कब्जा है, लियन करा हुआ है बैंक में, तो आप बैंक से परमिशन लोगे, बैंक दूसरी पार्टी की क्रेडिबिलिटी चेक करेगा कि हाँ जी वो पार्टी ठीक है, वो भी, अगर आप मेरा पैसा नहीं दे रहे हो तो फिर मिस्टर बी जिसको आप सेल कर रहे हो वो कंपनी मेरा पैसा. ऑलराइट, गुड इवनिंग खुशी मेहरा. इट्स ओके, यू आर लेट टू द क्लास, डोंट वरी. आनंद रुति, गुड आंसर्स. It terms as a breach. Okay, very good. Company goes into liquidation, breach of terms and condition. Almas, Naina, all of you have given the correct answer. So what happens when the company goes into liquidation? Soumya, Priyanka Pandey, great. Anubhav. So when the company goes into liquidation, then we are not sure if the assets will be sufficiently left or not. So we ask the company that please crystallize the charge now. And after that, company cannot sell the assets without the permission. Absolutely correct. All of you have revised very nicely and good answers have been. After that, section 77 we will discuss, which says that whose duty it is to get the charge registered. Now let's make the picture very clear in our mind. If the picture is clear in our mind, then the learning becomes very, very easy. So what was the case? ABC Limited was the company. It has given its office building as a security to HDFC Bank. Now ABC Limited, it's duty of ABC Limited to get the charge registered. ABC Limited will go to the ROC and will file form number dash and dash. In case it is the borrowing of the debentures, which form ABC Limited needs to file with ROC? CHG 9. Everybody is jumping out of the seat and answering. Oh my God, one child memory has answered wrong. Others, everybody have answered it correctly. Okay, not to worry, Priyanka Pandey. Don't worry at all for this, okay? CHG 9, oh, Anushka has played safe. CHG 9 for debentures, ma'am, and CHG 1 for others. So my question was for debentures. So absolutely correct. Kritika, Rekha, all of you. Anandruti, so many new names I can read today. Palak Sharma, very nice, excellent. CHG 9 is the correct answer for debentures. And if it is any other than debentures, then it is CHG 1 form. All right, children. So this form has to be deposited with ROC within how many days? How many days ABC Limited will go? Within 30 days. But ABC Limited was very busy. It failed to deposit it within 30 days. Then within how many days I can go? Next 30 days. You use the word either 60 days from the date of creation or you use the word next 30 days. All right. So we have been following next 30 days by paying the additional fees or ad valorem fees. What fees I need to pay over here? Additional fees or ad valorem fees? Excellent. Excellent. Priyanka, no, it's not ad valorem. We are on the additional fees as of now. Shalja, Ritika, Naina, good. Palak Sharma, no, it's additional fees. Okay. Okay, Krushi Mehra, good. Yes, Priyanka, nice. So 30 days, you pay the normal fees. Next 30 days, you pay the additional fees. Now, if it's still not filed with the ROC, then next 60 days, now comes your ad valorem fees. So what was ad valorem fees? Can anyone raise their hand and explain me what is the meaning of ad valorem fees? Harshita, Anubhav, correct. Kirti. Yes, Priyanka Pandey, good. Who will explain me the meaning of ad valorem fees? The rate remains the same. It's percentage based, but the amount of loan keeps changing. So if I have given the loan of 10 lakhs, for example, ad valorem is 5%. So what will be 5% of 1 lakh? 5,000 rupees. If I have taken a loan of 10 lakhs, then 5% will be 50,000 rupees. So the fees keeps on varying depending upon the amount of loan that you have taken. Everyone is clear on this? So once you have learned it, don't forget doing the writing practice, children, because when we are doing it with the teacher, we are revising it, we know all these things on our tips. But the writing practice is very important. अगर लिखकर नहीं देखा, कोई क्वेश्चन पढ़कर नहीं देखा, प्रैक्टिस नहीं करा, तो फिर हमारी टेंडेंसी हो जाती है भूलने की. So you have to do that. Now the charge can be created against the assets in India only, right? We cannot create a charge against the assets outside India. Am I right upon this? Can I create a charge on my property which is in Dubai, Chennai, China or Singapore? Chennai, I would say. For 6 months extension, we have to take. Asta Sethi, that 6 months thing is before 2nd November 2018. So now 2nd November 2018 has gone back since long time. So we have to follow the provisions of 30 days and 60 days. Okay? जो बुक में लिखा है आस्था सेठी वो आफ्टर 2nd November 2018 वाली प्रोविजन हम अब फॉलो करते हैं अंडर सेक्शन 7. No, ma'am, you are not right. Charge can be created against the assets outside India. Absolutely correct. All those who have answered it wonderfully. Anushka, Memediti, all of you, Miss P. Yes, inside and outside India, both. Then there is a copy of instrument. What is this copy of instrument? What is this copy of instrument? The document which is for the signed between the borrowing company and your lender bank. So ABC Limited and HDFC Bank have signed a document. This is known as copy of the instrument. This has to be filed with ROC along with the verification. What verification certificate is required? If the property against which charge is created is outside India, who all needs to sign it? Come on, hurry up. We did a question also in the previous class. Who all are going to sign if the property is situated outside India? Common seal, director, CS, or any other person who is interested. Now, why this any other person is here? Because your property is in Dubai. So they don't want to bother you much. They said put a company seal, director or CS. If they are available nearby, they can sign. Or an authorized person of the charge holder. इस पे भी बात करते हैं. But under any other some other person also other than company who is interested. So they try to tell you that don't need to be bothered so much. We just need the verification document. Anyone who is sitting over there abroad can just do the verification and can sign and send us the certificate. We are okay with it. But if the property is situated in India, then they cannot be any other person. Then it has to be a director or company secretary or authorized officer of the charge holder. What is the meaning of this line? Authorized officer of the charge holder. Charge holder कौन है? Bank. अगर कंपनी रजिस्टर नहीं करती है, आरओसी के पास नहीं जाती है, तो कौन जाएगा चिल्ड्रन? अंडर सेक्शन 78 टुडे वी विल अंडरस्टैंड that then bank will go and get the charge registered. So the authorized representative of charge holder can also sign it. Can the authorized holder of charge holder sign in both the cases? Yes or no? Anubhav says no. Soumya says no. Now you have listened correct. Yes, it's okay. It's okay. It's okay. Everybody has now answered. Rohit also says no. Why no, Rohit? I'm asking authorized dealer of charge holder can sign in both the cases. Yes, ma'am. Only some other person ka hai difference in common seal. So if you ask me, two people who are different is under the common seal and some other person. These yellow ones are only in case of property outside India. All these purple one, company secretary, directory and charge holder authorized person, they are same in both the cases. क्लियर हो गया? एमसीक्यू में आ सकता है क्वेश्चन, भूलना नहीं है. This table we have revised, we know. Can we ask for the extension of time limit? What is required? If I am trying to take the extension, I went to ROC, I said, okay, look, I could not come in 30 days. I'll be coming in next 30 days. What do I need? I need a declaration signed by the company secretary that intervening creditors will not be effective. Excellent. Soumya, Almas, Rajveer, all those who have quickly answered, declaration have to be filed. Now, the last question for the test goes to the class is, you have all answered me that we are going to file the application with ROC in CHG 1 or CHG 9 in case of debentures. The fresh certificate which ROC will be issuing me is in which certificate? Form number CHG 2. And if I have done any modification, what is the meaning of modification? So, for example, I took a loan from HDFC Bank and they were giving me a loan at the rate of 9%. Now, because of stringency in the money market, they have changed the amount of loan and they have increased it up to 11%. So I filed the document earlier with ROC that it was 9%. Now it has been revised to 11%. So do you think some modification has happened in my charge? So I need to file this modification again in the same forms, that is CHG 1 or CHG 9, depending upon debentures or non-debentures. But ROC will issue me the fresh certificate of modification of charges in CHG 3. And examiner will give you one interesting question in the MCQ. The issuing of CHG 3 or CHG 2 by ROC is a conclusive evidence of dash. It is conclusive that all the rules of Companies Act 2013 and Chapter 6 have been complied with related to registration and modification of charges. So this was the last topic that we did. No charge created by the company will be taken into account by the liquidator. So if company's liquidator is appointed and if you have not filed the charge with ROC, then it will become the unsecured creditor. What is the meaning of unsecured creditor? I have an office building. I have given it as a security. So from whom I have borrowed the money, they are my secure creditors because security has been given. And if no security is given, if no security is given, then it is unsecured creditor. And partial one, that is also considered to be unsecured. Now, if you are an unsecured creditor, what will happen? Who has no security for the debts? So you are being created as if there is no security for your debts. Yes, ask the Sethi, we will do that point, don't worry. So if no security has been given, now what will happen? That tomorrow, let's imagine that scene. Asta, listen to this point. I'm explaining this line only, that it shall not be prejudiced. Please listen. So now liquidator will sell the assets and pay off the liabilities. So when the company goes into liquidation, who is paid first? First, the secured creditors will be paid. The company will make the payment first to the secured creditors, and whatever balance is left will be given to the unsecured creditors. Now, this HDFC Bank, who has given us a loan of 10 lakh rupees, security was given for the office building, and it was not registered. So he has fallen under the unsecured creditors. The assets of the company were 15 lakh rupees. And the secured debts, other secured debts were for rupees 10 lakhs. So what will happen? These 15 lakh assets, liquidator will first pay off the secured debtors, because whenever the payment is made, first is making the payment to the secured ones, because security has been given. We want to release a security, and only 5 lakh balance will be left for HDFC. Now, although company will still make the payment, but out of that office building security, out of these assets, HDFC can only claim the balance amount. Nothing in this section shall prejudice any contract or obligation for repayment secured by a charge. I told you in the last class also, now you will be given 5 lakhs, although the payment of 10 lakh will still be made. Although the repayment of loan of 10 lakh will be made, shall not prejudice means it shall not impact them. HDFC को नुकसान नहीं होगा, only he loses his priority. Means earlier, I was a secured asset, I was a secured creditor. Now I will simply go and stand in the line of secured creditors and I will get my payment. But my charge is not registered. I have become unsecured. Now I cannot claim the money from that security because I am considered unsecured. I will still file a case against the company and the repayment will be made. This is the meaning of this line. That it will not prejudice any contract. The contract that the instrument document that borrowing company and lending bank has signed, that still remains valid. पेमेंट तो मेरा देना ही पड़ेगा, चाहे आपने उसको रजिस्टर कराया था या नहीं कराया था. अगर आप नहीं कराते हो तो मैं सिक्योरिटी में से पैसा रिकवर नहीं कर सकता, बिकॉज नाउ आई हैव बिकम एन अनसिक्योर्ड डेट. All right. Another important consequence is that the charge holder loses his priority, means now the secured creditors will come and they will take their money and I will be little behind them. Now, the more of this picture will get clear when we study section 78. Application for registration to be filed by section 78. So section 78 starts where section 77 ends. It tells you that now company fails to register the charge. तो मैंने अभी आपको समझाया कि HDFC Limited will become unsecured creditor. So I don't want to face this crisis. So who will be in trouble? The bank will only be in trouble. ना company को तो कोई trouble नहीं हो रहा है. Company ने तो charge create करा. उसकी responsibility थी under Companies Act section 77 register कराना. Company भूल गई. कंपनी को नुकसान हो रहा है, कंपनी को नहीं हो रहा, चार्ज होल्डर को हो रहा है, बैंक को ट्रबल हो रहा है. Oh my God, look at this company. It has not registered the charge and tomorrow if it goes into liquidation, I will become unsecured. So bank will go running to the registrar and tell them, ROC, listen to me, company failed to got the charge registered. So I have come here to get the charge registered for myself. Because bank will be in trouble if the charge is not fixed. Now let's see the situation. What will happen? Everybody is with me? Yes, Priyanka Pandey, bank will be in trouble. अब हम समझते हैं क्या होगा. अब क्या होगा? अब bank will go to ROC. ROC will ask him, who are you? How does he knows you? He has links with the company. This HDFC bank has come to ROC and now he's ROC will go, bank will go to ROC and ROC will ask, who are you? Means actually मैं नहीं पूछेगा who are you. कहने का मतलब है he will be in doubt that it is company's property. You are HDFC bank and you are asking me, please do the registration of charge in my name. He will send a notice immediately to whom? हमारे एग्जाम्पल में कौन था? ABC Limited. He will tell a notice to ABC Limited. Look, ABC Limited, HDFC Bank has come and he's telling me that your property has been given as a security. Is it true? Should I trust the bank? He's asking for a no objection certificate. No objection certificate means आपको कोई दिक्कत तो नहीं है अगर मैं बैंक के नाम में चार्ज रजिस्टर कर लूं. So company has to create the charge. Company fails to do it in 30 days. Charge holder will go to the ROC. ROC will send a notice to the company requesting for a no objection certificate. Now, within how many days this no objection certificate has to become? Within 14 days, company should send this no objection certificate. Within 14 days, if company is registered by itself and has the sufficient cause that why charge should not be registered, the registrar will not allow the registration. So company has to send that we have no objection. Please register the charge within 14 days after giving the. And if no objection is received in 14 days, then ROC will go ahead and register this charge. Okay. So bank will go to ROC. ये रहने देना, who are you? ये तो समझाने के लिए था. ROC will send the notice to ABC Limited asking, is this true? He will ask for no objection certificate. 14 days, company should send this no objection certificate. Then ROC will go ahead and register this charge. Let's have a quick revision. Company has to file the charge. Company fails to do in 30 days. Now you will ask me, ma'am, company still had the extension time period. So there is a loophole. If company has requested for the extension of time limit, then bank, please wait. Let the time get over. So here we are assuming company has not done in 30 days and company is not in a mood to get the extension. Then charge holder will get up and he will go to the registrar. Registrar will send a notice to the company. If no objection is received, he will get the charge registered in 14 days time period given. If the objection certificate is received, if company says, no, wait, ROC, we don't know HDFC Bank, हमने तो कभी इसको security दी ही नहीं. If company, either the company will say, okay, fine, don't worry, we'll register by ourselves, or they will give the reason why this charge should not be registered. Any of the two things has to be done. Then the registrar will not allow the registration to be done by charge holder. So basically, children, what is happening? If I am a company and I have taken a loan from a bank cannot on its own terms and condition get my charge registered with ROC. ROC will first ask Harleen ma'am that this is your company. can we register the charge? 14 days time period will be given to me, that in 14 days, please tell us yes or no. If I say no, please don't register, I want to register by myself, I want to take extension, then he will not register. Or I give him the reasons that I am not having good terms with this bank, I have never given this security, please don't register, then also ROC will not register. But if you don't give any reply in 14 days, ROC will assume there is no objection. Or if you tell them that there is no objection, then ROC will register the charge in 14 days. Yes, Mr. M.A., if company fails to give, then it will be assumed after 14 days, ROC will move ahead for the registration of the charges. Now, this bank had to bear all the fees because you did not do your work. Now, bank had to go and do the registration. Such person will be entitled to get the amount from the company, all the fees and additional fees that he has paid to the registrar for the registration. Very, very important point. Will bank do this registration at his own expense? Whatever fees, whatever additional fees bank has incurred to get this charge registered, it will recover it from the company. So can the bank recover the amount fees from the company? Yes or no? Absolutely, yes. Bank can recover the amount from the company. All right. Good, good, good. Section 79. First, we will do 78 and 79 from my presentation. Then we will read each and every line and the examples which are given in the study. It says provisions of 77 relating to registration of charge may apply to a company acquiring any property subject to a charge within the meaning of this section or to any modification which is made for this charge. So section 79 basically talks about modification of charges. It says either any property which you are giving subject to a charge, this section is applicable to that, or any modification you are making. Modification means any variation. Variation का मतलब क्या होता है? Changes. Any changes you make in the terms and conditions of the loan that you have given. For example, changes in the rate of interest. I told you earlier it was 9%, now it is 11% by mutual agreement. Or by operation of law, law ने change कर दिया है. या फिर there can be other variations. For example, the loan was to be repaid by 31st July 2025. Now you said, I want to gain extension and bank has given you extension of 1 month. Now the loan is to be repaid by 31st August 2025. So your security will also be seized for 1 month more. So you have done this variation. Now again, you need to file this modification. Section 77 relating to registration of charges shall apply in both the situations. वो कह रहे हैं चाहे आप फ्रेश चार्ज रजिस्टर कराने जाओ तब भी आपको 30 डेज 60 डेज का टाइम है, चाहे आप मॉडिफिकेशन को रजिस्टर कराने जा रहे हो CHG 1 एंड CHG 9 में तब भी आपको 30 डेज एंड 60 डेज का टाइम दिया जाता है. The provisions are same. The only difference is rule 6 says where the particulars of modification have been registered, the registrar will issue the form in CHG 3. Clear to everyone? Here the form number CHG 3 will be used. So how will a copy of an instrument evidencing the creation of charge required to be filed with the registrar be verified? We did this question. Verification has to be done if the property is outside India by directors, CS, company seal. Yes, Anubhav, we will definitely see the forms today. And if the property is in India, then only the two parties. We have done this one also before 2nd November 2018. Charge definition was done. Okay, let's do this question. Renuka Soaps and Detergents Limited realized on 2nd May 2019 that the charge created on 12th March in favor of bank was not registered with ROC. 2nd May 2019 को charge हुआ था, released on 2nd May. They realized the charge which was created on 12th March. So 12th March, 30 days, 12th April, let's assume, and next, how many days they have taken? Next 60 days was still there. Next 30 days had to be taken. So by 2nd May, they realized that it is not. What procedure should the company follow to get the charge registered? What would be the procedure if the company realized its mistake on 7th June instead of 2nd May? Very, very interesting question. Apply your brains, take 2 minutes, think about it, absorb your knowledge, and with your open book system, give me correct answers in the chat box. I give you 2 minutes, analyze and answer. Yes, everyone, give the correct answers. Ad valorem fees, excellent. 60 days time period. First 30 days, very nice. Next 30 days additional fees, good. Excellent, Anushka, Anubhav, Almas, all of you. So this is how you have to attempt the question. First, you will give the relevant provisions. Now, just pay attention because this is the last lecture of registration of charges today. So I wanted you to understand how you have to write the answers also in the exam. So you will write that relevant provisions. The charge in the present case was created after 2nd November, to which the provisions of 2nd Ordinance 2019 are applicable. So even if you don't remember this company's amendment 2nd Ordinance, you can simply write down that the present case is after 2nd November. So the provisions which are to be followed will be different from the charge which was created before. Initially, the charge together with the instrument was filed, has to be duly filed with the certificate within 30 days of its creation. In this case, the charge was not filed in the 30 days. However, the registrar has the power to give the extension to another 30 days on the payment of additional fees. So the first part is on the payment of additional fees you can do. Taking the advantage of this provision, they should have filed it after satisfying by making an application and showing a sufficient cause for not filing within 30 days. So I told you, you have to take a declaration also and you have to give them sufficient reasons why it was not filed within 30 days. Now, if the company realized the mistake on 7th June, then a period of 60 days has already expired. Another opportunity is that the company gets 60 days and the company will have to pay ad valorem fees. So the 60 days have expired on 11th May. Company can still get the charge on 60 days from 11th May after paying the ad valorem fees. So company is required to make the application giving sufficient reasons for non-registration of the charge early. Very good, Mr. M.A. Absolutely correct. The delay that you are saying for 120 days, so 120 days from the date of creation is correct. Very nice. All of you have given wonderful answers. So now my only purpose was to tell you how you have to write these answers. Okay? The registrar of the company is not bound to issue notice to the charge holder if the satisfaction of charges you have still not done. Second part we can do. Leave the first part. Registrar of companies may allow the company or charge holder to file intimation within a period of 300 days of the satisfaction of charges. Satisfaction we have not done. You cannot do the first part. So we'll come back to this. 76 we have done. Yes, we have done. Okay. I'll take your questions. We'll come back again. First, let's do some part of the chapter. Okay, MCQs. Interest shall lien created on the property or assets of the companies on any of its undertakings or both as security is known as a debt, charge, liability, or hypothecation. So this one is very, very simple. It is known as charge. B. Did we do these in the previous class? Yes or no? Any person acquiring property on which charge is registered under section 77 shall deem to have the notice of the charge from the expiry of 30 days, from the date of application, from the date of acquiring the property, or from the date of such registration. Any person who is acquiring the property on which the charge is registered shall deem to have the notice. Deem to have the notice is under section 80, which you have not yet done. Still, let me see your vague answers. So from the date of registration is the correct answer in this one. All right, children, let's leave the question answers. Let's first complete the chapter because the question answers are all jumbled up from the entire syllabus. So what is the meaning of deemed notice of charge? That's why you were not able to answer that. All of you have given just a tukka in A, B, C, D, everybody. हाँ नहीं आता. Anu said no ma'am ये नहीं आता. हाँ इसीलिए नहीं आता क्योंकि ये topic करा नहीं. So were any charge? This another tip I wanted to give you when you are revising for your final exams also. You have your exams in September. So once you're done with the entire syllabus, please pick up only those RTPs and MTPs, only those chapters which you have thoroughly revised. Then only try to see the questions from those chapters. Because children, what happens is sometimes we have not revised a particular chapter and we try to see the questions from this chapter and we tend to confuse ourselves. फिर वो डर लगता है, वो फेयर आता है, जैसे अभी आया आपको, ओ माय गॉड ये क्या लिखा है, तो पढ़ा ही नहीं. So always do your revision first, complete your notes and learn everything and then pick up the MTPs and RTPs related to that respect. Now, where any charge or any property or assets or undertaking is registered under section 77, any person acquiring such property, assets or any interest shared shall deem to have the notice of charge from the date of registration. अब सबको आता है section 80 में क्या लिखा हुआ है? From which date it becomes? Okay, Priyanka, we will get the chapter 5 notes. Chapter 5 and chapter 6 notes will get uploaded within a day or so. I think they're planning to upload them together, okay? Now it's clear. Very good, Soumya. Naina, from the date of registration. Now you know why there was D part was the correct answer. Because law says in the section 80, what is the meaning of deemed notice of charge? What is the meaning of deemed notice? You have done deemed prospectus, deemed notice, doctrine of constructive notice. Anyone remember? So when we said doctrine of constructive notice, we told you when MOA and AOA get registered with ROC, they become public documents. Anyone who is dealing with a company is presumed to have knowledge of these documents. पढ़ा हुआ है हमने ये MOA and AOA के बारे में. कोई भी कंपनी के साथ जब डील कर रहा है, they are presumed to have the knowledge of this thing. Now, if you have got your charge registered, it will be kept, entry will be made in the register of charges and it will be kept open with the ROC. So now everybody who is dealing with a company, tomorrow my company Reliance, it wants to sell its big office building, which is there in Delhi. They want to sell their office building to any other company. So that company will go and check with the ROC. I hope there is no charge against this property. This property is not provided as a security. So it is your responsibility, whosoever is buying my assets, any person who is acquiring my assets of undertaking or any part, will be assumed that they have this notice of the charge from the date of registration. Means जिस दिन ये charge register हो गया, तब से ये public document बन जाएगा और ऐसा मान लिया जाएगा कि जो भी मेरी कंपनी के साथ डील कर रहा है, उसको इस charges के बारे में पता है. So any person who is dealing with my company is presumed to have the notice of this charge. Now let's try solving this question. So any person acquiring property on which the charge is registered shall deem to have the notice of charge. Deem notice is given under section 80. So from which date you will get the notice? On expiry of 30 days, or on the application of charge, or on the date of acquiring the property, or on the date of registration. So the correct answer is from the date of registration, it becomes effective. देखा सबका आंसर कैसे करेक्ट आ गया? Shalja, Memory, Soumya, Anurag, Kirti, Anushka. Because now you have read it, now you have got it in your subconscious mind, and now you can relate the topic also. Clear है सबको? I think let's go to the study material first because there are too many examples given over there which we should do. So we have done till here. Deem notice of charges. All the charges have to be filed with the ROC. We understood. Now, children, any person who is lending money against the security will buy and refer to MCA website. Okay, charges दिखा भी देती हूँ, certificates भी. MCA की website होती है Ministry of Corporate Affairs. उसी पे ही हमारे forms download होते हैं. उस पे सारी information जाती है कि किस company के against कौन सा charge किस asset के against create हुआ. Because forms तो वहीं से download करते हैं, CHG1 form, CHG9. तो उसमें फिर So it is a document is known as constructive notice, means implied. Constructive notice means public will have the knowledge. Even the third party has not referred to the public document. Still we are assuming. याद है ना हम कैसे assume करते थे कि अगर आप हमारी कंपनी के साथ डील कर रहे हो तो हम ये assume कर रहे हैं कि आप पढ़कर आए हो. आपने पढ़ा है या नहीं पढ़ा, that is your fault. That is not company's fault. Certificate in CHG2 is for fresh registration. CHG3 is for modification. We have already. Where any charge is registered, any person acquiring the property will have the notice. तो इसको important mark कर लेना कि PC के ऊपर हमने MCQ करा है. So this is an MCQ based question. From the date of registration is the answer for this MCQ. Every person proposing to deal will verify whether the asset. I told you that if I am buying your asset, I will verify whether this asset has a charge or not. From the records of charges maintained at RO office. So before entering, I will open the register of charges and which are kept at the RO office. I will try to check. If he enters without inquiring and suffers a loss because of the charge, he cannot claim the loss because he shall deem to have notice of the charge. Let's assume another case. There is a company, ABC Limited. You told me, ma'am, this office building, it is charged, created with HDFC Bank. And ABC Limited is a good company. It has filed and registered the charge within 30 days. Now, from the date of registration, it is deemed to be noticed within everyone that it is a registered charge. Now, there was another company, PQR Limited, which is buying this asset of ABC Limited. ABC Limited didn't tell them that there is a charge against it because they applied Section 80, that you should be having knowledge about this. Tomorrow, ABC Limited failed to repay the loan of HDFC Limited. What will HDFC Limited do? They will sell this office building and recover their money. PQR Limited is shocked. This is my property. I purchased it from ABC Limited. I paid 1 crore. Why are you selling it HDFC Limited? They said, PQR Limited, don't you know that there's a charge created against this property? You have not studied Companies Act Chapter 6 Registration of Charges, in which Harleen ma'am told you that Section 80 tells you that if there is any charge, you will not claim any loss because it is your duty under Section 80 to read the document before entering into any kind of contract. So what will happen, children? Will PQR Limited suffer a loss? Yes, ma'am. He will suffer a loss. They cannot claim their money. समझ आई कहानी सबको? Story, have you understood? I've told you a nice story on the basis of these 2 lines, just trying to explain you that you cannot recover any loss. It is the duty to raise the charge. Absolutely, Mohammed Farhan. It is my duty to tell them that this charge created. But if I don't tell them, Section 80 is giving me the liberty that there is a deem notice. My responsibility, Mohammed Farhan, was to get the charge registered. Now it is a public document. If you are dealing with my company, please, you should have done your responsibilities and duties. So it is your responsibility. Yes, Anubhav, you can digitally verify. गुड, अंडरस्टूड. खुशी मेहरा मैम हिंदी में बता दीजिए, इतनी तो हिंदी बोली मैंने अभी आपको. Yes, yes, Priyanka Pandey. This is in chapter 2 also, constructive notes. Okay, Kushi Mehra, I'm telling in Hindi also, those who have not understood. हिंदी में इसका मतलब ये है कि अगर मैं आपकी कंपनी से कोई एसेट खरीद रही हूँ और उसके अगेंस्ट अगर चार्ज क्रिएट हुआ है, तो ये मेरी रिस्पॉन्सिबिलिटी है कि आरओसी के पास जाकर चेक करना कि इस प्रॉपर्टी के अगेंस्ट कोई चार्ज तो नहीं है. मतलब किसी को एज अ सिक्योरिटी तो नहीं दी गई है ये प्रॉपर्टी. वो परचेजर की, द पर्सन हु इज एक्वायरिंग दी एसेट, एक्वायरिंग मीन्स जो खरीद रहा है उस एसेट को, उसकी जिम्मेवारी. ओके, क्लियर खुशी? Miss P is asking, ma'am, if PQR Limited ask ABC about the charge and ABC there is no charge, then you're lying, then you're creating a fraud, Miss P. We have penalties for this. Don't try to cheat, okay? Here I remain silent. I did not tell. So silence is not fraud. Compulsory registration acts as a method of preventing the company from offering the same asset. So that is why we have created a charge, and people don't make this kind of mistake. They always try to make that. So whenever you buy a second-hand car also, you must ask your parents today कि अगर आप कोई गाड़ी खरीदते हो तो आप चार्ज चेक करते हो. देखो, once you're buying a new car from the dealer, there is no charges. But if you buy any second-hand car, anything from any other person, you always try to see whether there is any charge against you. So try to check it out today, whether people check it out or not. Anyone who is buying the assets, they will always try. Yes, and why this is done? Because compulsory registration is necessary so that the people know that the same asset is not offered as security in order to prevent the frauds happening. Clear? Let's do example number 5. Vishnu Marketing obtained a term loan of 50,000 rupees, 50 lakh rupees from Alpha Commercial Bank. Who is the charge holder and who is the company? Vishnu is a company. Alpha Commercial Bank is the charge holder. Charge was created on one of the buildings and got the charge registered. Later on, if the building is sold to another person, say Neeraj, then he is deemed to have the notice of such charge. So अगर ये बिल्डिंग किसके पास रजिस्टर्ड थी? कमर्शियल बैंक के पास. चार्ज रजिस्टर्ड था, हाँ जी, आरओसी के पास रजिस्टर्ड था. अब क्या विष्णु नीरज को बताएगा? नीरज अगर ये प्रॉपर्टी परचेज कर रहा है, so there is no need of Vishnu Marketing Limited to tell them. It is the duty of Neeraj. It is presumed. ऐसा मान लिया जाएगा that Neeraj knew about this mortgage. Neeraj cannot plead against such presumption by saying that he did not know about the charge if he suffers a loss at a later date because of the mortgage. Not tomorrow again, Vishnu defaulted, commercial bank will sell this asset, Neeraj will not get anything. So Neeraj started crying that I did not know that this property is mortgaged. Can he recover the money, children? What will happen? Can Neeraj recover the money? No, ma'am. Why? Which section is applied? Section 80, that it will be consumed, it will be presumed that he has the notice. He cannot claim any money because it is assumed that he already had the notice of the charge. Everyone clear on example 5? Consequences of non-registration we have already discussed. Let's do example number 6. Bank A gave the advance money of 1 crore. Bank A advanced 1 crore to Vasudha Medicals Limited against the security of the company's land and building. The charge was created by deposit of title deeds on 1st June. The company did not register the charge within 30 days. What is happening in this question? What is happening? Bank has taken an bank has given a loan of 1 crore to Vasudha company. Security has been given against the land and building. Charge was created by deposit of title deeds. Here is your meaning of interest or lien given. On 1st June 2024. Company did not register within 30 days. Subsequently, the charge was registered on 12th August. Is it within the dates, children? Okay. After the payment of ad valorem fees and providing the sufficient cost. Meantime, B Bank advanced 2 crore of loan against the same security on 18th June. This charge was registered on 26th June. Before reading the question, please tell me who will get the priority on this, Bank B or Bank A? Who will get the priority of, जहां तक मैंने सिर्फ अभी क्वेश्चन पढ़ा है, मुझे प्लीज बताइए, who will get the priority, Bank B or Bank A? Bank B will get the priority. This is the meaning of this line. When we have read that the other bank loses its priority, means Bank B's charge is first registered. So now if any default happen, Bank B will be considered as a secured debtor and he will recover the money first. Now Vasudha Limited went into liquidation and how much money was left? 2 crore rupees. Loan कितने कितने थे हमारे? 1 crore का loan यहाँ है and how much loan? The other bank has provided 2 crores. So Bank B will get the repayment of loan. Oh my God. Now the loan assets were only for 2 crore rupees. How much I have to pay to the Bank A? 1 crore. How much I have to pay to Bank B? 2 crore. Who will get the payment? Bank B. Whole of the 2 CR. Why Bank B gets? Because but Bank A will not get anything because subsequent registration will not prejudice the right of Bank B, which obtained its right before the charge in favor of bank was registered. Astha Sethi, you have raised this question. Please listen carefully now. We are doing the example for the same. Bank A पहले लेकर आया for the loan, but his charge was registered in August. Meanwhile, the same security was given to Bank B. His charge was registered on 26th. Now, just because Bank B is already registered charge, this Bank A will not prejudice, means it is not going to affect. वो ये नहीं लड़ सकता कि मैंने पहले लोन दिया है, मुझे पेमेंट मिलनी चाहिए. Will not prejudice means it will not affect the rights of B because their charge is registered first. In favor, then the Bank A was actually registered. So Bank B gets the priority over Bank A, even though the charge was created later. But children, my dear students, will Bank A get the payment? Will Bank A still get the payment? Yes or no? Yes, absolutely. पैसा memory से no. पैसा नहीं दोगे, loan नहीं पे करोगे. I told you that it will not prejudice the contract that we have. So Bank B will get the repayment from the security because his charge is registered. So priority is given to Bank B. बाद में Bank A का पैसा दिया जाए. Clear? So we have done section 77, 78, 79, 80. Revise these 4 sections, read the illustrations, and let's take a small break here. Then we'll proceed here. So many questions for you, so please revise it. Yes, compulsory registration होता है. अनुभव, it says the registration is compulsory. तभी तो आप assets को secure कर सकते हो. Say Anubhav, if I have 10 buildings and I have given them as a security to a particular bank, I never did my registration. How will people come to know that I have given a security? So that's why section 78 has been mandatory. That if I don't register it, bank has to get it registered. So it is a compulsory registration. That is why chapter 6, we are studying registration of charges. It is important and compulsory to register the charges so that person who is buying your property should know that it has already been given as security. It is not free from encumbrances. Yes, absolutely. Whether you do or the charge. Okay? So यहाँ पे break ले रहे हैं हम. अशोक सर. Bhumika is asking, is there any punishment? Definitely, we'll be doing the punishment also in a while. Yes, Astha, it means that they can sell the security and they can recover their money. So here is an MCQ 3 in front of you on the screen. A charge was created by C Limited on its office. Yes, Bhumika, if the company has not registered, then the charge holder will get the charge registered. We'll read section 78 provisions once from the study also. A charge was created by C in its office premises for the term loan of 1 crore availed from Next Bank Limited through an instrument of charge executed by both the parties. Inadvertently, the company did not get the charge registered with the concerned ROC within the first statutory time permitted, and the default was made known to the lending banker with a stern warning to take immediate steps for rectification. Last date within which the company must register the charge to avoid paying the ad valorem fees is. So the instrument is executed on 16 February 2019. By when the charge should get registered if you want to avoid the ad valorem fees. Quickly calculate the number of days that you not learned and what will be the correct answer. Soumya, Priyanka, Rajbir, Ray, all of you have given the correct answer. Harshita, absolutely correct. Kushi, excellent. So all of you have given the correct answers. 16th of February, 30 days, and next 30 days till the original fees will be counted. So 17th of April is the correct answer in which you can avoid the ad valorem fees. Since the charge has been created on and after 2nd November, no registration in 30 days, 60 days from the creation and payment of additional fees. So B is the correct answer. So we were just completing this point over here. I hope everybody is clear on section 80 as well as on the non-consequences of non-registration is crystal clear to everyone. Here is the application for registration. Bhumika, the doubt that you have asked will now get more clear over here because let's have a quick recap from the study also. We have seen the above discussion that non-registration on delay will affect the interest of the charge holder. So I told you that the charge holder, that is consequences of non-registration में हमने ये पढ़ा है कि charge holder जैसे bank B and bank A को दिक्कत हो रही थी अभी. So therefore he has the power has been given. This whole table we have understood over there. If a charge is created, if it is primary responsibility is the company's to do it within 30 days. The person in whose favor the charge is created is known as charge holder. He can also apply to the ROC if the charge is not registered. Now, when he will apply to the charge holder, registrar will give a notice to the company, and if no objection is received, then he will proceed within a period of 14 days. So how much time period is given to the company to reply for the no objection is 14 days. Registrar will not allow the registration if the company want to register itself or they have given the sufficient cause that charge should not be registered. And who will pay the fees? Who will pay this fees? The bank will have to pay the fees or the company will pay the fees under section 78. Very good, Priyanka Pandey. Excellent. Others, who will pay the fees? Soumya, good. Anushka says bank will pay the fees. So Anushka, bank will pay the fees, but the recovery of the fees has to be done from the company because company was at default. Yes, Almas, Sarshida, good. Kushi, Anurag, everybody has given the correct answer. After that, we have also done section 79 from the chapter. I hope no doubts in section 79. It is basically talking about the modification of charges. What I wanted to cover from here is what kind of modification can be there. There can be a modification in the rate of interest. Variations is also kind of modification, even if the rights are assigned to a third party. So you said that now I don't want to, I have sold my property to somebody else. Okay, Rohit Ranjan, not a problem in that. Garisha, you're trying to ask anything? Rohit, your queries are coming here. You can ask your questions from the admin portal also. All right. So variations can happen even in the interest when the charge holders are assigned. So the rights of charge holders are assigned to third party. It is also modification, means now somebody else is going to make the payment rather than the company making the payment. Some of the examples of modification is varying in the terms of contracts. Varying means changing the terms and conditions of the contract, existing contract. Enhancing or decreasing the limits. Enhancing means increasing or decreasing the limits for which the loan was taken. Where a modification is by ceding a pari passu charge. Now, what is the meaning of ceding a what is the meaning of pari passu charge? Can anyone tell me? Pari passu charge means proportionate share in the mortgage property is created. When it is ceded means when it comes to end, the charge holder will become a second charge holder, and as such his entitlement will be subject to full satisfaction of the claim of the first charge. Now, what is the meaning of pari passu charge, which is coming over here is, that means on the equal footing. So he's trying to tell you that here the pari passu is on the proportionate basis. Suppose HDFC Bank has taken a loan of 5 lakhs against the property of 1 crore, and Axis Bank has been given the same asset as a security for the loan of 10 lakhs. So they are in the ratio of 1:2 you have to pay to them. So whenever this asset will be sold, 1:2 ratio will be used for making payment to HDFC and Axis Bank. So that is on the uniform basis they will have to be made payment. Where a change in the rate of interest other than bank rate. Now this is very interesting. What is the meaning of bank rate? Suppose HDFC Bank has taken certain loan from RBI. Sometimes banks also take internal loans. Now RBI has asked for a security from HDFC Bank. So RBI will not get the security registered. It is not applicable to the banking companies, this provision of Section 77. It is only if company is providing any security and HDFC Bank has given a loan. But if HDFC, Axis Bank, any other bank is taking the loan from RBI itself, for that loan, bank rates are used. So here, bank rates, if the bank rates are varying, whatever the rates RBI has decided with the bank, if they are varying, then it is not a modification. Any other change in the rate of interest will be considered as a modification. If there is a change in the repayment schedule of loan, not applicable to working loans which are, so they have the short-term loans which are repayable on demand, it is not talking about that, but any change in the repayment schedule. So the loan was to be paid by 30th of August 2024. Now, and every month you were paying 1 lakh, 1 lakh, 1 lakh. Now you said, no, we are in the early need of money, so the loan will be paid by 31st March. Instead of 1 lakh, 1 lakh, 1 lakh, you pay me 2 lakh, 2 lakh, 2 lakh, so that the early payment is happening. So any kind of limits that you're changing, increasing or decreasing, varying the terms and conditions, repayment schedule is being changed, rate of interest is being changed, or there is partial release of the charge on a particular asset or property. So you have released the property partly. So you said one asset I have given you as a car and another asset I have given you as a building. So now I want to release the car because car is open for sale. Somebody I want to sell it. I am ready to repay the loan. So now this partial release is happening. So now some partial release is happening. Then also you will have to apply in CHG 1 and CHG 9 for the modification, and ROC will issue a certificate in CHG 3 that this modification has been done. Clear? This reminds me about the forms also. So everybody is clear about the CHG 2, and CHG 2 form is issued for what? CHG 2 form is issued for what? For the fresh certificate of issue by the company. Okay, let me open the forms. CHG1 form. Children, CHG1 form is used for what purpose? Can anyone tell me? Now we're going to see the forms for which you have been eagerly waiting. So see how beautifully they have written that CHG forms relate to section 77, 78 and 79. All these three sections, right? Because 79 में भी तो modification का ही लिखा है ना. 77 में भी आपने फाइल करना है अगर आप जाते हो कंपनी हो. आप नहीं गए, चार्ज होल्डर जा रहा है तो वो भी तो CHG वाले लेकर जा रहा है ना ROC के पास. Other than debentures, very good. And 79 is for modification. So all these three sections are covered under CHG1 form. This is the form for registration, creation or modification other than the securities related to debentures. And it includes the modification or reconstruction asset as well. So what is the instruction kit? USIN number will be written, global location number, name of the company, address will be given. Now this form is for, you will take over here, whether it is for creation of charge or modification of charge. Why two different things? Because if it is for creation, ROC will reply in CHG2. If it is for modification, ROC will apply for CHG3. Whether the applicant is a company or a charge holder, whether you have come under section 77 or whether it is beyond 30 days but within 300 days, this was for the before 1st November 2018. Give reasons for the delay. If beyond 300 days, what is the reason for the delay? Whether the asset is created for the charge for the property inside India or outside India. ये सारे points आपने अभी पढ़े हैं. Type of charge, किस तरह का charge है, tangible assets और intangible assets also. Okay, if yes, lead banker's name, finance is involved, joint charge is there, all these points. Particulars of the charge holder, which bank is there, specify the name of the favor of the banker or assessee who against whom you have created this charge. Amount secured by charge. Okay. In case of modification, enter the amount secured after modification. Amount in words will be entered. Rate of interest, terms of payment. These are the terms and conditions which I was talking about. Any variations happen in these terms and conditions, then you will have to file a modification. Extent on operation, for how long the charge has been created. Date of instrument creating the charge or evidencing the charge. So whatever instrument the company and the bank has signed. Date of acquiring the property, amount of charge, particulars of the charge. Show the particulars of the property, complete address and location. So what all properties are there. So that's why it becomes a public document because all the properties names are given. So I told you if you have 10 properties, whatever charge is created, their address will be bearing here. Whether any property or interest under reference is not registered in the name of company. If yes, name the person who's so, whether it is your property or you are buying it from somebody else. Okay. Date of creation or modification and all these points, instrument, particulars of joint holders. Optional attachment means अगर आप कुछ और भी attach करना चाहते हो and declaration has to be given that I am the authorized by board of directors because the board of directors CS will sign it and it is to be digitally signed. Designation has to be mentioned. The charge holder, PAN of the charge holder to be digitally signed by TSC. Is that clear? All of you? So on the similar terms, we have the CHG1 form you have seen. CHG9 is also similar. It is just that it is used for the debentures. So सिर्फ एक ही फर्क होगा CHG9 में, वो यहाँ लिखा होगा that this is for the application or the modification of charges for the debentures or the rectification of particulars. So modification can also be done. It is only for the debentures. Again, pursuant of section 71, subsection 3 means 71 क्या में क्या दिया हुआ है? Section 71 में क्या दिया हुआ है? जल्दी बताओ मुझे. उसमें सिर्फ 77, 78, 79 आ रहा था. इसमें 71 भी आ रहा है because 71 is debentures. Yes, yes, Priyanka Pandey, absolutely. Rest all is same, children. All the details are same. Here they have only included the copy of resolution authorizing the debentures. So you refer to section 71, you will remember. Now which form we had to see? CHG2. So this is how form number CHG2, the company is going to issue. ROC is going to issue it. According to section 77, 78 of the Companies Act and rule 1 of rule 6, corporate identification number of foreign company, GLN number, name of the company. This is to certify that the provisions of chapter 6, the above mentioned charge, on this date, this much amount has been created in favor of the company. To secure the amount has been registered and assigned a charge identification number as mentioned in the register of charges. So we're going to do the next topic, register of charges, where this entry will be made. So this is your CHG2 form, which is written as Certificate of Registration of Charge. And now I'm going to show you CHG3. What is CHG3? For the modification of the charge. The certificate of modification of charge, again same details, and they will mention that this detail will also be entered in the register of charges. Chapter 6 provisions have been complied. So सिर्फ हेडिंग में चेंज है, यहाँ पे सेक्शन 79 क्लॉज बी की बात हो रही है, CHG2 में सेक्शन 77 एंड 78 की बात हो रही है, क्योंकि CHG3 का जो है वो इट इज इश्यूड अगेंस्ट provisions have been given under section 79 and rule 2 of rule 6, certificate of registration of modification of charges. Is that clear? Did you enjoy watching the forms? When you're studying practically and you see the downloaded forms from MCA website, then it becomes more interesting. Okay. Now let me take you back in your study material. So section 81 talks about the register of charges. So I just told you in the forms also we have seen. Yes, they are. You can edit them. Thank you so much, Harshida. She has written, it's really helpful to relate and put it in the memories. Thank you, ma'am. Thank you so much. Sangeetvani, thank you, all of you. Good. You enjoyed the forms because tomorrow when you become budding chartered accountants, you might be filling these forms. Register of charges to be kept by the registrar. So registrar will maintain. Now what has happened, children? Either you went as a company or the charge holder went under section 78. All the provisions are crystal clear in our mind. Now we have got the charge registered. Now the ROC has issued at CHG2 or CHG3 according to the form. Now ROC is going to make the entry in the register of charges, which will be kept at the registered office also. All this register of charges to be kept by the registrar, it will be kept at the registrar. That's why we said it's a deeming provision, because anyone who is entering into any contract. All right, Priyanka has written, ma'am, practically bhi humne law pad liya. It's no longer a theoretical. So that's great. So we are solving questions and practically also understand. That's fun. So register will after this, when we will be starting MGT, you'll be understanding that all this management and administration, it relates to your chapter of starting with the registers to be maintained of shareholders and debenture. So there you will understand that how the registers are kept. But as of now, we have just seen 3 registers for the depositors that we have done, for the deposits accepted, and now we are seeing the register of charges. The register will be kept and keep the register containing the particulars of the charges which have been registered in the same form and manner. Again, see, MCA website, they have given you the link also. Particulars of the charges maintained on the MCA website shall deem to be the register of charges for the purpose of section 81. So here it takes you to the Ministry of Corporate Affairs link. This is the place. See, ICAI CA is also given over here. So MCA website, where you can go and see how this is how your MCA website looks like. And you can download the company's forms. Here the company forms are given, from where we download the company forms and try to show. Okay. So this is how your MCA website looks like. Right. So now inspection of these registers, such registers shall be kept open for inspection by any person can come and pay the fees and register these register of charge. But you know what very important thing over here is register will be open for inspection by any person only on the payment of fees. But if the member of the company wants to inspect it or the creditor wants to inspect it, then there is no need of payment of fees. So inspection can be done by any person on payment of fees. But if company is member only or the creditor wants to inspect these registers, then no fees is required to be paid. Section 85 contains the provisions which where the register to be kept by the company. Every company will keep the register. I just told you they will keep it at the RO office. Wherever is the RO office of the company, this register of charges will be kept there. It will include all the floating and fixed charges created on different property and assets. Copy of the instrument will also be kept along with the register of charges. So you will also keep that instrument copy, the document which has you have signed with the borrowing company and the bank lender. That instrument copy shall also be kept at the RO office. Company will enter all the particulars of the registers in this particular of the assets and undertakings against which the charge has been created, and all the satisfaction and modification of charges will also be kept over here. Entries will be made for creation, modification, and satisfaction. We are yet to do satisfaction of charges, children. We have still not done section 82. After this, we will be doing section 82 क्योंकि उसके detail में end में दी है section 82. Okay. Thank you so much, Sangeetwani. I'm so happy to read your comment. God bless you, child. Thank you. So now, how we are trying to understand about this, that is how the register of charges can be inspected. Entry will be made. Who is going to sign? All the entries are authenticated by a director or secretary. So generally the registers are kept under the company secretary provisions. That's why Companies Act is most of the CS, company secretary, are appointed in the companies to take care about the company law provisions. So secretary CS of the company is going to authenticate all the registers, the entry, and also the director. Inspection, who can inspect these instrument of charges or register of charges? Instrument of charges को अपनी language में लिख लेना, that document of agreement. It's instrument of charges का मतलब agreement document जो हमने बनाया है company and bank के बीच. How can you inspect this? These registers can be open for inspection during business hours. So anyone can come and inspect and see that what are the properties against which the charge has been created. Any member or creditor can inspect it without any fees. And if anybody else wants to do it, they will pay the fees. What is the fees? They have not written prescribed fees. And any restrictions can be imposed by the company by its articles. Company can impose any restrictions by its articles. And for how long these registers are to be maintained? The registers shall be preserved permanently, and the instrument creating a charge shall be preserved for a period of 8 years from the date of satisfaction of charge. Now, this is something which is very important and interesting, which is again a part of your LCQ. So they will ask you for how you have made a register of charges. ROC will keep this register of charges, and where it has to be kept? It has to be kept at the registered office of the company also. All the creation, modification has to be made, entries and kept at the registered office. Also, the instrument has to be kept. How the inspection can be done by any member of creditor without any fees. Anybody else is trying to inspect it, they will have to pay the fees. These registers will be maintained permanently, but the instrument which was creating a charge has to be maintained for a period of 8 years. Now, from what date? You created the charge on 1st December 2024. The charge was registered, date of registration. Repayment of loan was made on 1st February 2026. Now your charge has got free. So from 1st February 2026, 8 years, this copy of instrument of charge has to be maintained. From date of satisfaction of charge means जब उसकी payment हो गई and charge of satisfy हो. Now the last section of this chapter, that is section 82. What is the meaning of satisfaction of charges? Where the company, here the company is required to intimate to the registrar. First, let's see my presentation because there are simplified notes over there, and then we'll come back. So these were the provisions for companies registers. We have all done these provisions from my study material also. They shall be kept open for inspection. Can I inspect the register of members? Oh, sorry, register of charges during business hours or non-business hours also? Only during the business hours. And what is the form number? CHG 7 is the form number where the company is keeping the register of charges. Okay, business hours, yes. Entries will be made, authenticated by director or CS of the company and preserved permanently. And instrument is preserved for 8 years. Intimation regarding satisfaction of charges. Now comes something which is little tricky and yes, Priyanka Pandey, all these sections are part. One by one, we're going to do them. Yes, agreement of charges, Anubhav, absolutely correct. Now pay full attention. Intimation regarding satisfaction of charges. We have done section 80, 81. We have already done section 85 also from the module child. That was section 85, okay? Now we are doing 84 has also been taken up. Now we are doing section 82. A company will give the intimation to ROC in form number CHG4 within 30 days on the payment or satisfaction. Now what is going to happen, children? Let's listen to the story. ABC Limited ने चार्ज रजिस्टर कराया था कि HDFC बैंक को मैंने अपनी ऑफिस बिल्डिंग गिरवी रखवाई है. हिंदी में यही था. CHG 1-2 में हम गए थे, 1-9 में गए थे, 2 and 3 हमें मिला था in return and we got this charge register. Now the due date of repayment has come. ABC Limited has repaid 1 crore rupees loan. Now please free my charge on my property. Whatever charge was created on this office building, now we are repaying the loan and getting it, this property charge free. अब हम छुड़वा रहे हैं इसको, चार्ज मुक्त करा रहे हैं, मीन्स फ्री ऑफ चार्ज. अब हम सेटिस्फैक्शन ऑफ चार्ज कर रहे हैं कि मैंने रीपे करके लोन HDFC को सेटिस्फाई कर दिया, मेरा चार्ज फ्री कर दो प्लीज, मेरी सिक्योरिटी के पेपर्स मुझे सारी चीजें वापस दे दो. How will you do that? You will go to the ROC in form number CHG4. There we were going in 1 and 9. Now you're going in form number CHG4 within 30 days of the payment. Can we extend the time period? Here you are following the same old provisions of 2nd November 2018 only. Extension will be given if you have not filed the application within 30 days. Please file the application within 300 days from the date of satisfaction, means additional 270 days are given. Additional 270 days are given to the charge holder or the company to file the CHG4. So what is happening? Loan repaid, company files CHG4 with ROC within how many days, children? Within 30 days of repayment. If not, then how many? I have written the word next. Next, 270 days. Or you say 300 days from the date of payment of. लिख लो फटाफट से. Now, what is ROC going to do? You go and file CHG4 with the ROC. Now, ROC will ask bank, listen, bank, company is saying payment is done. Is this correct? Earlier, ROC was sending the no objection certificate to company that bank is asking me to register you. Is this correct? Now ROC is asking bank that listen company, listen bank, company is saying that payment is done. Is this correct? Here bank will give no objection certificate. My dear students, can you make a vague guess within how many days? Bank will give no objection certificate within 14 days. Thank God the provision is same of 14 days. आपको कैसे पता था? आपने पढ़ लिया था पहले? सबने ठीक आंसर दिया. Good. Oh no, ma'am. Just a guess. Great. Very nice. So 14 days, he has to give this notice within 14 days that yes, the payment has been made and we have no objection. It's a good company. It has repaid its loan. Let's have a quick recap from the notes, what is written over here. Loan repaid, company will go to the ROC in form number CHG4 within 30 days. Now the company will go in CHG4 within 30 days. And if company fails to file the application within 30 days, then how much time period is given? 300 days from the date of payment or additional 270 days. Notice to the charge holder by the registrar. Here the ROC will give the notice to the bank. Please give me a show cause notice within 14 days whether the satisfaction should be recorded or it should not be recorded. Now, if no show cause is given by the charge holder, then he will enter the memorandum of satisfaction. अब charge holder ने कुछ नहीं कहा, वो चुप रहते हैं, तो फिर मैं क्या करूंगी? Then I will register the charge, satisfaction of charge. If no notice is sent, it will be assumed that everything is fine. Intimation to the registrar is in the form and signed by the charge holder. But if any show cause is given, then the registrar will record the note and inform the company. कई बार क्या होता है चिल्ड्रन, बैंक ना एक बैंक कह देता है कि नहीं 1 करोड़ का था, अभी हमें पूरी पेमेंट नहीं आई है, 99 lakhs आई है, तो बैंक आरओसी को बोल देगा कि रुक जाओ, अभी नो ऑब्जेक्शन है, पूरी पेमेंट होने दो, फिर ही रिकॉर्ड करना सेटिस्फैक्शन ऑफ चार्ज. बेसिकली हो क्या रहा है, प्रैक्टिकली सोच के देखते हैं. पहले हिंदी में बताती हूँ फिर इंग्लिश में. एक कंपनी है जो बैंक से लोन लेकर आई है, अब उस लोन के अगेंस्ट उसने सिक्योरिटी दी, अब लोन रीपे कर रही है, तो आरओसी को कह रही है प्लीज मेरी सिक्योरिटी छोड़ दो, मैंने लोन रीपे कर. आरओसी कहता है बैंक को, बैंक सुनो ये सिक्योरिटी छोड़ दे, अब ये कह रहे हैं रीपे कर दी. तो बैंक अपने डॉक्यूमेंट्स चेक करेगा, अगर तो लोन पूरा रीपे कर दिया है, बोलेगा हाँ जी छोड़ दो, रिलीज कर दो, हमारा काम खत्म, आज के बाद हमारा डन है, सेटिस्फैक्शन ऑफ चार्ज हो गया, खत्म, नया चार्ज आएगा फिर. बट अगर बैंक को डाउट लग रहा है कि मेरी पेमेंट रहती है, शो कॉज नोटिस, उसे शो कॉज करना पड़ेगा, नोटिस रीजन देना पड़ेगा कि क्यों इसको सेटिस्फैक्शन को रिकॉर्ड ना कर. सो इन इंग्लिश, कंपनी विल गो टू आरओसी, आरओसी विल आस्क बैंक, if there is any objection, please send it in 14 days. If no objection in 14 days, then we are going to report the satisfaction of charge. Clear? All of you? So now in which certificate ROC will issue the certificate of satisfaction of charges in form number CHG5. This chapter is so amazing because the forms are so simple. Learning के साथ-साथ forms है. CHG1 and 9 देंगे तो क्या मिलेगा? CHG2 fresh certificate, CHG3 modification. CHG4 फाइल करते हैं तो क्या रिटर्न में आता है? CHG5 for the satisfaction of charges. So what will the company file for satisfaction of charges? CHG4. And what will the company get from ROC? CHG5. And this record of instrument creating a charge or modification will also be preserved for a period of 8 years from the date of satisfaction of charges. We just did now in the previous point that for 8 years from the date of satisfaction, this instrument which is creating a charge has to be maintained. So this is your summary taken from Saransh. Institute has beautifully made Saransh for you, in which all the summaries are given of all the chapters. All right. So this is your satisfaction of charges. Let's read. Company will give the intimation to the registrar within 30 days. If not intimated, 300 days will be allowed. Second point, the registrar will send the show cause notice within 14 days. If show cause is shown, he will record and inform the company. If no show cause, then he will proceed. No notice in case of intimation is specified and signed by this exception we will cover in the next point. That is, अगर मुझे कोई शो कॉज नोटिस नहीं आता, कोई इंटीमेशन नहीं आता, then what I have to do. However, specified IFSC public and private company within 300 days time period is given to them. So these are specific exceptions. Power of the registrar to make the entries of satisfaction of charges. Now section 83 क्या कहता है? Somebody was waiting for section 83. So registrar on the evidence being shown on the satisfaction will enter that the debt for which the debt against which the charge has been paid, satisfied, and the property may enter in the register of charges. So basically, अब वो अपने register of charges में enter करेगा कि this property is now free from security, free from the charge, and the loan has been repaid. He will inform the affected parties from the dates of making the entries, and the form and the certificate will be issued in CHG 5 form that the memorandum of satisfaction has been recorded. So power of registrar to make the entries. Sometimes registrar may on the evidence given to his satisfaction. Now this is what exception he was talking about. In section 82, we have learned that either the company or the bank is trying to tell them that the satisfaction has been done. Sometimes registrar has also been given the power to do it suo motu. Suo motu means on his own. Suo motu means on his own, अपनी मर्जी से अगर किसी और ने evidence दी है, evidence means proof. If somebody else other than company and bank comes and gives a proof to the registrar that look, that property against which the charge was created, it is free now. Please issue CHG 5. So then under section 83, power has been given to the ROC that he will enter the memorandum of satisfaction and he will issue CHG 5. So what is the difference between section 82 and section 83? In section 82, company is going and intimating the ROC that please release my property papers. Satisfaction is over. Loan has been repaid. CHG 4 will be given. CHG 5 will be given. MCQ will ask you, can registrar suo motu on his own issue CHG 5 without having CHG 4? You will say yes. Under section 83, registrar has been given the power that if he gets any evidence on behalf of anybody else, comes and tells him, then yes, he will enter the memorandum of satisfaction of charges and will issue the CHG 5 form. Section 84 says sometimes children, a receiver or manager is appointed for your security. So here section 84 tells you where appointment of a receiver or manager has been done, again intimate the company and registrar of the same. If a person who has been appointed, an order of appointment has been taken, if the person appoints such receiver and has the power, he will give the notice of this instrument within 30 days of passing the order to the ROC, and the registrar on payment of this fees will register this receiver that now this person has come. See now CHG 1, 2, 3, 4, 5, 6 forms you have done, but CHG 6 form was left somewhere. So section 84 is specifically made for CHG 6. CHG 6 is nothing. It is simply trying to tell you that sometimes you appoint a receiver or manager for your charge. So whenever you appoint a receiver for your charge, then you have to intimate the company and the ROC. If the company has appointed such person within 30 days of appointing this person, it has to file an application with the ROC. It will have to intimate the ROC in form number CHG 6. CHG 6 form, he will have to intimate that this receiver was appointed. On ceasing to hold the appointment means when he leaves this appointment, when he is done, then again the person so appointed will give the notice to the company and register. So when this person is appointed, within 30 days, he will give the notice that I have been appointed. When this person is leaving the office, then again, he will inform in CHG 6 that he has now left the office. Not a very important section, but yes, it's given, so we read. Now section 86, punishment for contravention. बहुत से बच्चे बोल रहे थे मैम अगर कंपनी डिफॉल्ट करती तो डिफॉल्ट में तो हम कभी छोड़ते ही नहीं है. मैंने आपको कहा था डिपॉजिट की भी पेनल्टी, 2 पेनल्टीज हमने करी थी डिपॉजिट. अगर रूल्स नहीं फॉलो करते हो, अगर 77, अगर सेक्शन 72 एंड 73 कॉन्ट्रीवेंट करते हो, दैट वाज एन इंपॉर्टेंट पेनल्टी. And punishment for contravention of registration of charges is also important penalty. And whenever you study chapter of dividend, that is also very important penalty. And also the chapter of audit, it is very important penalty. ये तो करनी ही करनी, ठीक है ना? ये तो करनी करनी, बाकी भी करनी है, but ये 4 अच्छे से लर्न. If any company is in default in complying with the provision of Chapter 6, liability of penalty of 5 lakh rupees and every officer will be liable for 50,000 if he willfully gives any false and incorrect information or he suppresses any material information which was to be given under Section 77. So there was an office building against which charge has been created. This was property A, but you said, no, it's property B. False information, incorrect information. You have created charge against ABC, but you said we have created charge against ABCD, 4. Or you have created charge against A and B only. You are suppressing, you're not telling about A, you're only getting B registered. So any kind of things you're doing, 447 will become up. One is that 5 lakhs and 50,000 penalty is there. But if any fraud is involved, any false statements are involved, any suppressing of material information, then 447 will also. And the last section, ma'am, पहले भी बोला था last खत्म ही नहीं हो रहा, ये सच में last. After that we have a test. Section 87, central government will order the rectification of registers in case of following default. अब आपने रजिस्टर में कोई गलती कर दी, आप चाहते हो उसको रेक्टिफाई कराना, तो कौन ऑर्डर पास करेगा? सीजी. So section 87 tells you CG has been given the power to order for the rectification of the register of charges. For example, any omission was made on the payment or satisfaction of charges, then it can be rectified. Any misstatement made which were previously filed with the registrar, it can be related to modification, satisfaction or anything. CG can ask for the rectification. So either you have forgot to intimate the ROC, the omission can be either you have forgot to intimate the ROC about the charges or you have made any misstatement for the modification charges or satisfaction charges, then CG can allow you the rectification. क्योंकि penalty बहुत harsh है ना, तो कह रहे penalty मत करो, हमारे से गलती होगी, rectify करा दो, तो CG के पास power है rectification. But before directing the time for giving the intimation for the satisfaction shall be extended, central government needs to be satisfied that default was accidental and due to inadvertence or some other sufficient reason and is not going to affect the position of creditors. Application in form number CHE 8 will be filed by the company and central government will do the rectification if he thinks fit. अब अगर रेक्टिफिकेशन तो आपने समझ लिया, सेक्शन 83, 82, 84 में कोई डिफॉल्ट हो रहा है, ओमिशन हो रहा है, तो हम कर देंगे, बट ये ओमिशन एक्सीडेंटल होना चाहिए, गलती से मिस्टेक होनी चाहिए. अगर आप जानबूझ के करोगे तो 447 से बचने मत आओ ना. जानबूझ के फॉल्स इंफॉर्मेशन दे रहे हो, सप्रेस कर रहे हो और फिर कह रहे हो सीजी को रेक्टिफाई कर दो. नो, इनएडवर्टेंस, एक्सीडेंटल, बाय मिस्टेक or some other reasons which is not affecting my creditors and shareholders, then CHG 8 form में application करेगी company and CG will make the changes in the terms and conditions as it thinks fit. Priyanka Pandey, when it will make an application in CHG 8 form, it will get it rectified. Okay. So now I give you small 5 minutes break over here. Please read the entire chapter because we have so many question and answers, MCQs and all the questions I'm going to ask you. So I give you 5 minutes. Please revise what we have done and then we'll proceed for the question answer. Welcome back. I hope you have read this in 5 minutes. Shall we start the questions? But before that, I just wanted to have a look into the study material also. I hope we have covered all the points. So for the satisfaction of charges, in which form company is going to file with the ROC? CHG 4, absolutely correct. And within which form ROC will issue the certificate? CHG 5. Very nice. And the records have to be preserved for how long? 8 years from the date of satisfaction. This is your point where the debt has been satisfied and property has been released and nobody has informed ROC. Then ROC on its own can also issue CHG 5. Intimation of receiver, we have already covered. Punishment is also clear. Rectification of registers. So all these points have been covered. Direct rectification can be done. He can also extend the time period for the rectification. This is a small amendment which you can read. And it is form number CHG 8 for the application. A charge was created by Sinus Software on its office premises, securing a term of 1 crore from next generation through an instrument of charge executed by both the parties. This similar question we have already done, 17th April, you already know the answer. Instrument creating a charge or modification shall be preserved for a period of dash years from the date of satisfaction of charges. Oh my God, look at the speed, 8 years, everybody has given the correct answer. This also we have done. Who cannot inspect the register of charges and instrument without paying any fees? Member, creditor, person other than the member, no person is allowed. ध्यान से सोच के देना बहुत easy है ये भी. Okay, definitely Priyanka, I will suggest you for that. Option C, very simple. No person is allowed. Why? Everyone is allowed to inspect the register of charges. I told you, members and creditors are not required to pay any fees. Any person other than the members and creditors will have to pay the fees. So all these questions you will write in your notebooks and you will try solving them so that you do it by yourself and understand how you have to write it. So now I am going to take certain tests of yours in which I'm going to ask you certain questions. But before that, in case you have any doubts, please feel free to ask your doubts. Anyone having any doubts, feel free to ask. No doubts? Everything is clear? Section 87, okay. No, Harshita, when the repayment has been made, then CHG 4 will be filed. Monthly, if you are making the installments repayments, then not once the full payment has been. Priyanka, if 120 days period have expired, then charge holder will get the charge registered if company has still not done. Yes, Nidhi, हिंदी में कौन सा explain करना है? हिंदी में explain कर दीजिए. Which point, Nidhi? Please write in the chat box. Ma'am, question number 6 explain. Okay, Sabah. Can you explain 87 once again? Okay, Anubhav, we will do section 87 once again, not a problem. Ma'am, section 83 एक बारी दोबारा करा दीजिए. चल, दोबारा फटाफट से कर लेते section 83 and 87 and Saba has raised a doubt in question 6. पहले question 6 भी देख लेते हैं. Where is question number 6? A company is required to keep a register of charges at registered office. Mention the provisions of the Companies Act in case of, this is very simple. Here, Saba, you simply have to remember all the provisions of register of charges that we have just discussed in the chapter that is related to section 85, that register of charges will be kept. CHG 7 is to be used, specifies all the charges and floating charges have to be included. Copy of instrument will also be filed along with this. Entry will be made. When to make these entries? Once the charge has been created or modification has been done. Who will authenticate? Either director or secretary. You can refer to my notes for this. It's more simplified over here. And also write about the inspection and presentation. All the points related to charges will have to be mentioned. Okay. So section 85 we have revised. Section 87 में किसी को doubt है. Section 87 क्या कह रहा है आपको? Section 87 simply tries to tell you that central government के पास power है रजिस्टर ऑफ चार्जेस को रेक्टिफाई करने का. रेक्टिफाई का मतलब क्या होता है? चेंजेस करने. ओके, तब करेगा अगर कोई ओमिशन है इन गिविंग द इंटीमेशन टू द रजिस्ट्रार विद रिस्पेक्ट टू पेमेंट और सैटिस्फैक्शन ऑफ चार्जेस और फॉर द पावर ऑफ, मतलब जब कंपनी ने CHG 4 दिया या रजिस्ट्रार 5 दिया, इन at this time if company has made any omission, has made any misstatement, then central charges. The time for giving the intimation shall be rectified. तो कह रहे हैं यहाँ तो हमें ज्यादा, and if you are giving the intimation for the extension, if any misstatement was made, then CG will make such that CG will say that this omission or misstatement जो भी आपने गलती करी है अपना CHG 4 फॉर्म फाइल करते हुए या फिर मॉडिफिकेशन फाइल करते हुए, अगर ये मिस्टेक आपने बाय मिस्टेक करी है, मींस इनएडवर्टेंस है या फिर एक्सीडेंटल. एक्सीडेंटल का मतलब क्या होता है? गलती से आपने मिस्टेक करा है, मींस यू हैव सम सफिशिएंट कॉज एंड रीजन टू प्रूव and it was not with the intention to defraud the creditors and shareholders, then CHG 8 में company application file करेगा and central government will deem fit, just and expedient. Yes, the order for rectification can be passed. Then CG will pass the orders for the rectification. Central government on the application filed in CHG 8, according to section 87, ये orders pass करेगा. क्या order pass करेगा? He will direct the rectification of the omission. Say, for example, some particular thing was to be mentioned in the register with the registrar. You have forgot to mention that. He will say, okay, it is an accidental mistake. Please now file it. Or time period for satisfaction was to be extended if the filing has not been done. Filing was to be done in 30 days. If not done in 30 days, 300 days from the date of satisfaction. If still not done in 300 days, CG is giving you the power, okay, give this more extension. If the filing is not done in 300 days also, then it will direct the extension of time period only if it is satisfied कि creditors को कोई नुकसान नहीं है and कोई गलत काम कंपनी नहीं कर. समझ आ गया सबको? Nidhi, you understood? I have explained in Hindi. Nidhi, inadvertence means आपने accidental mistake करा है, गलती से mistake करा. Section 16 में आपने इसके बारे में पढ़ा हुआ है, जब आप नाम गलत ले, ठीक है, सेम मीनिंग है यहाँ पे. CG के पास जाएंगे और CG मान गया तो yes, Anubhav, this is basically your avoiding the penalties because now rectification is being. But section 86 gives you a harsh penalty, even 447 तक हम जाओ. Section 83 में doubt था किसी को? Section 83 is nothing. Section 83 is simply telling you power of registrar to record the entry of satisfaction of charges and issue CHG 5. So section 82 tells you that company went to the ROC that look ROC repayment हो गया, please मेरा charge free कर. Company did the repayment and kept on silent. It did not go to the ROC. Things were moving fine. ROC got to know from the neighbors of the company or from XYZ, any other person, that look, ROC, they forgot to tell. Then section 83 has given a power to ROC that, okay, if I come to know about this thing, then I will issue CHG 5. बस इतनी सी बात है सेक्शन 83 में, और कुछ। ठीक है, क्लियर? और डाउट्स? निधि, आई होप आपको हिंदी में सब समझ आ गया, मैंने आपको समझा भी दिया है। अनुभव, आई होप योर डाउट्स आर क्लियर। हर्षदा, थैंक यू, योर डाउट इज क्लियर, ग्रेट। सबा, शकील, आई होप योर डाउट इज क्लियर नाउ। Any other doubts, children? So, Soumya, I simply try to tell you that it is not going to affect the other party. Simply whatever I have told you, that much is fine for you to learn. Okay? Now, let's do some questions from the chapter. From nationalized bank against the hypothecation of stocks and accounts received by the company. Instrument creating the charge was duly signed by the company and the bank. Company is not willing to register the charges. Please discuss if there is any provision where the charge holder bank can get the charge registered. When can the registrar refuse to register the charges in the present scenario? Take 2 minutes, think and do it. Everybody has to answer it. Everybody has to answer it. Section कौन सा है? $78, everyone? Company failed to do, banker will go, banker will file it, charge holder. Section 78, beta, why did you write 77, Sabha and Nidhi? 78 is the correct answer. Yes, Harshada, absolutely correct. Priyanka, good. Rajveer, correct. Soumya, good. Yes, Almas, absolutely. He will not register if he get the no objection. Sangeetvani, good. So this is how you will have to write. Section 78 will give you the power. If it is not done within 30 days, then he will apply, charge holder will go and apply in the same form and time. So the bank can get the charges. Registrar will refuse if she are not allowed, if he has itself, the company wants to enter or the company has given the show cause notice that why the charge should not be registered. Okay, let's do one more question. DN Limited hypothecated its plant to a nationalized bank and availed a term loan. Very good, Naina. Correct answer. The company registered the charge with ROC. Company has settled the term loan in full and requested the bank to issue a letter confirming the settlement of the term. Bank did not respond to the request. What are the relevant provisions to register the satisfaction of charges? State the time frame up to which the ROC may allot the company to intimate the satisfaction of charges. We have discussed section 78. Now the question relates to which section? Satisfaction of charges. CHG 4 जाएगा, बैंक CHG ROC CHG 5 देगा. किस section में पढ़ा हमने अभी ये? Section 82. Very good. Very good, Mr. MA. That's a nice copy paste that you have done from the module, but that's correct. The answer is absolutely correct. Company should be filing with 30 days, next to 70 days. Rekha, Memory, Almas, Kirti, Anubhav, Harshada, all of you are absolutely correct. Soumya, very nice children. Naina, good. Mamadi Sethi, Memory. Feel so proud teaching you students that you pick up the things and you analyze the knowledge and then you reply back. So applause for all of you. Well done. So the same answer, 82, 30 days, extension period of 300 days will be given for the intimation of charges. Clear? You want to do one more? Okay. ABC Limited created a charge in favor of OK Bank. The charge was duly registered. Later, the bank enhanced the facility by another 20 crores. Due to inadvertence, this modification in the original charge was not registered. Can you suggest something? Company has created a charge in favor of bank. The charge was registered. Later, it enhanced the facility by 20 crores. Modification was there, but this modification was not registered. What will happen then? Inadvertence, Nidhi. Tell me. Rajveer, very good. Company will get modified. CG के पास जाएगा. February, very nice. Thank you so much, Priyanka Pandey. Don't worry when I'm going to miss you for the sessions when I'm not with you. But I hope to see you soon back in the sessions again, okay? Section 87, rectification by CG, very good. Yes, CHD 3 for modification also you can mention. So here it is typically talking about section 87, where I told you that CG has the power in case of any omission has been made or any omission related to modification has been made, then CG will just see that it is not because of it is any accidental and because of any inadvertence, then only he will empower to make the changes. Is that clear? Is that correct? Everybody is on the same page. Let me see if there is anything else that we can do more. We can do 2 more MCQs. We have already done from the module also. Okay, this MCQ. The registrar shall keep the register of charges which shall open for inspection by the company, charge holder, any holder on payment of fees or any person. So this charge register that we are maintaining is kept open for inspection by whom? Can only the company inspect it, charge holder, any payment of fees or any person? ध्यान से सोच के बताना. Okay, Priyanka, I will suggest you for the visualization stories. D is the correct answer. D, because it says that how you have to, any person can go and inspect the registers. Ma'am, while learning sections, how to make story to visualize, suggest if possible. So while learning the sections, children, you simply have to remember it the way we have done it in the class, like deposits and charges are 2 chapters, which I would suggest you to learn the sections and forms also, because the chapter is designed in such a. So if you ask me about visualizing a story, one story we have taken in registration of charges, that there was ABC Limited Bank. It went to an ABC Limited Company. It went to HDFC Bank for getting its loan amount, and office building was the security. Now, entire chapter you have to revolve around this story. When the repayment happens, satisfaction happens. When the charge is registered, CHG 19 will be coming up. 2 and 3 you're getting for modification. So that is how for all the chapters you should create some visualization in your brain so that you're able to learn the content in the same. But deposit and registration of charges, I'm telling you, they're the tiniest chapters. Try to learn them now only. So then on the later dates, you're just flipping through the pages. I'm just seeing if we can do one more question. All right. So this is the last question from my side. No, Harshada, no need to refer any other important books or anything else. ICAI material is in itself sufficient for all this. Okay. Star Limited is having an establishment in Canada. It took a loan creating a charge on the assets of the foreign establishment. Company received a notice from ROC for not filing the particulars of charges created on the property of the asset situated outside India. Can we create a charge on the property situated outside India? Yes, ma'am. Company wants to defend the notice that it is not the duty of the company to file the particulars which are not located in India. Do you agree? No, ma'am. We have already done that. We can have the charges which are property situated outside India. Therefore, it is liability of the company. Under Section 77, it is the duty of the company for the property situated outside India to file a charge with the registrar. Also, the properties which are within India or outside India, both are included. Here, the loan was taken on the property which is outside India. Therefore, it is the duty of the company to get it registered. Hence, the stand taken for not to register it is not correct. Apart from that, you can give a little bit more reference of Section 77 also. Clear है सबको? Very good. Yes, MA. Absolutely, memory. Very good. Everybody's clear. So, any doubts, students? Anything else you want to ask? I hope you have enjoyed doing all these chapters, deposits, prospectus, registration of charges. Now we will be starting with MGT after this, Management and Administration. So I told you in the previous class also, your first module, one book is over. This Saturday, Sunday, sit down with your notes, complete everything. When I say notes, ICAI study material module is the Bible for you. Whatever you have been referring to my notes and making the highlighters in your module, everything should be ready. ठीक है मैम एग्जाम में आंसर कैसे लिखेंगे निधि जिस तरह से मैंने आज आपको प्रोविजंस फैक्ट्स ऑफ द केस एंड कंक्लूजन वाला आंसर कराया है उसी तरह से आपने आंसर्स प्रेजेंट करने ओके थैंक यू सो मच नायना आई एम ग्लैड टू नो दैट यू एंजॉयड माय क्लास थैंक यू सो मच I hope you don't have any doubts, students. If you have any doubts, I'm still here for 1 or 2 more minutes. You can ask me your doubts. Okay. Even on the portal, the students, nobody any doubts. All right. Now I can just get a thank you message and Miss P. Thank you, child. Thank you so much. We'll be starting with most likely management and administration after this, children, with the second book. Okay. All right, students. Thank you, Soumya. I'm glad all your concepts are clear. Thank you, Rajveer, Anubhav. So no doubts. Yes, Mohammed Farhan, thank you so much. So students, please keep revising, keep studying, keep making your notes and do well. Thank you, Rekha. Thank you, children. No doubts. So I think we can wind up. Questions taken in the class help us to check our understanding. Thank you, ma'am. Thank you, Harshita. I'm glad to know that. Thank you so much. Also, the questions given in the study material, please revise them and start and try writing them. Any case study, you should break it up in 3 paragraphs. Provisions of the case, facts of the case, and conclusion. Okay? Yes, Naina, all these questions will be there in your chapter number 5 and 6. Also, you will get on the admin portal. All right, Mr. P. Majahid, thank you. All right, children, thank you so much and see you soon in the next class with a fresh chapter. Let's see. All right, goodbye, students. Yes, it's done.